Good morning. I hope everyone is doing fine and healthy. That was, as we know, the police don't stand so close to me from Zenyatta Mondada. I had that vinyl myself. My name is James Daniel, and you might know me from previous webcasts. I'm an attorney with Holden Litigation. I'm head of the Workers' Comp Division, and I am here to present a fascinating program with two fascinating people. These are people I highly respect, and I'm going to be the guest host today. Today is the 11th of June, 2020, and today we're going to talk about class actions with a couple of hotshot lawyers, both with Holden Litigation. However, before we do that, I would like to discuss a few things from the Holden Institute. You know, those people are working constantly trying to keep us updated. And that is the Holden Institute at Bletchley Park, taken from the United Kingdom's Bletchley Park intelligence agency during World War II. We thought it appropriate to do the same and give it a nod. Our last conversation with you was June 4th, and we've had some things occur that have been somewhat remarkable. In fact, we've had a situation where it looks like there's beginning to be some form of double bounce with the reopen. Dr. Fauci has recently described COVID-19 as his, quote, worst nightmare, end quote. He compared it to Ebola and AIDS, both of which are bloodborne and not as transmittable as this malady that we're dealing with here, this nightmare, according to Fauci. When you compare the two to COVID-19, what you find is that while the others are bloodborne and it takes some effort to get them, you can get a transmittable COVID from 8 paces away if someone sneezes. It's pretty scary. If you want to know what that looks like, remember what it looks like when you're breathing outside in February. That's how far it travels, if you can image that in your mind. Recently, there have been hundreds of class action lawsuits filed against businesses, price gouging, health issues. It's pretty shocking. And that's what we're here to talk about. The UN won't even be gathering this year, and it's been 75 years that the UN has been in action, and this is the first time in 75 years they're not meeting in person. Total COVID-19 cases have surpassed 1 million. They've almost gotten to 2 million. I think the last I saw was 1,990,000. This is significant, and that's a new number. Tesla workers, the car company, testing positive for COVID-19 after defying public health orders. It's pretty shocking that some of these folks are not taking this as seriously as they should. Additionally, at least 28 states are failing to follow CDC guidelines on reporting new cases. That, again, is shocking. That's food for thought. And what I would like to do is introduce you to our panelists. And our panelists, get this off. Our panelists this morning are, there we go. Sorry about that. Our panelists this morning, I'm going to start with Elisa Hopkins. Elisa Hopkins works with us at Holden Litigation. We are extremely happy to have her here. She's a law review journal editor from the University of Tulsa. She's been a lawyer for about 7 years. She has also got an MBA. She's known for her talent at legal writing, but she's also now head of our COVID team, pretty much. I'm lucky to share the screen and the office with Elisa Hopkins. Our other attorney is an attorney from Holden Litigation down in Texas, our Texas office, Kristen Lawhorn. She's a 10-year lawyer and a graduate of one of my favorite schools, SMU Dedman School of Law. She's managing partner of our Dallas office and 2 times Super Lawyer winner in the Rising Stars of Texas. With that introduction, I would be more than honored to have both of you chime in and tell us what you know with regard to class actions.
Thank you, JD. I am very excited to be back, especially talking about one of my favorite areas, which is class action lawsuits, and especially when it comes to COVID-19 litigation. And that is because we have never seen anything quite like this before whenever it comes to class action lawsuits. And that is because, one way to say it is, no one is safe exactly from these types of lawsuits. Every industry appears to be affected and quite frankly is subject to these types of litigation when it comes to COVID-19. Specifically, we're seeing already lawsuits, hundreds of them being filed across the country. And these are against different corporations and carriers across the industry. We're seeing class action lawsuits against insurers, against travel and event providers, class action lawsuits against financial institutions and debt collectors, against retailers for price gouging. We've seen some very interesting ones in that regard filed lately against both Amazon and eBay. We're seeing class action lawsuits against manufacturers and retailers for of professional protective gear and products, and also against issuers. Some of this is obviously very complicated. I find it interesting. Some other people might find it a little bit frustrating or confusing. Especially out of Texas, it appears we have seen a very noticeable uptick in COVID-19 class action lawsuits being filed recently, which is a little bit surprising to some people, a little bit interesting. And I know that Kristen has, being in Texas, been on top of this and is up to date on all of the class actions that are being filed right now in Texas. So Kristen, I'll turn it over to you to give us a little bit more information about what's going on there.
Thank you, Alisa. And as you stated, there is no industry that is immune from the effects of COVID-19. But one of the industries that has been hardest struck is the airline industry. And in Texas, there was a case filed on April 22nd in the Northern District of Texas in Fort Worth. It is Ward versus American Airlines. And in this case, you have an Arizona resident who's filed a lawsuit against American, seeking a nationwide class of American airline ticket holders who have not been refunded the cost of their tickets from March 1st until today. So in this case, before COVID issues arose, you had an industry-wide practice where if an airline canceled a flight on their own, the ticket purchaser was entitled to a refund. But that's not what's happening right now. Instead, American Airlines is offering consumers the ability to either rebook their trip or providing them with a travel voucher. In this petition, one of the main arguments that the American airline ticket purchasers make is that we are now living in very trying times where there are now economic hardships that did not exist just 3-4 months ago. And they don't want a voucher. They don't want to rebook their trip. They want their money. For a lot of people, this refund could mean that they could pay their bills, put food on the table for their families. So it's just not acceptable to them that the American Airlines is only offering the ability to rebook or to get a travel voucher. Now, this is not a claim that is exclusive to American Airlines. All of the other major airlines also have suits against them right now. It's important to note that United Airlines, Southwest, and Delta are also have suits against them for refunds, and they are now seeking class certification. And Alisa, what do you think are some of the potential defenses that these airlines are going to raise due to these class action claims?
Well, it's really going to depend, I think, on the wording of some of the contracts they have with their customers. For example, a lot of major corporations, when it comes to consumer contracts, have force majeure clauses, which is basically if an act of God occurs, then they're not liable for breach of contract. I would also argue probably that say there is no breach in terms of they are able to substitute services of the equivalent. So that wouldn't actually constitute a breach. That could be another defense. Also, with COVID-19 and all the lockdowns, everything going on, frustration of purpose or just the impossibility to perform these contracts, as there have been obviously major travel bans and a lot of airlines are unable to actually fly to these different locations. That could be another defense I could see them raising.
Yes, those are some very interesting defenses. It will be equally as interesting to watch how these play out in court. It was also very important to note that back in April, the Department of Transportation basically told the airlines, hey, look, we know things are different right now, but you do need to honor the fact that you need to refund these ticket holders their money. So I really believe that right now, we already know the airline industry has been impacted greatly, but I feel like there's more to come. People are coming for them, for the airline industry. But again, as you stated, there are other industries that are also being affected. There's a lot of event cancellations that have been going on. We even had the 2020 Summer Olympics that were canceled. And recently in Texas, we had South by Southwest Festival canceled. That's something I've always wanted to go to, and I guess this year was not my year again. But back on March, the city of Austin, due to COVID, basically canceled the South by Southwest Festival. They wanted to keep the citizens of Austin and all of their guests, safe, and they were not able to comply with social distancing guidelines at the festival, so it was canceled. So at that point, you had the plaintiffs involved in this suit, which is Bromley versus South by Southwest, which was filed in the Western District, Texas Federal Court. The plaintiffs in that case, as well as other similar situated contract ticket purchasers, they basically called and emailed South by Southwest, and they're like, hey, your festival has been canceled. I paid money for my ticket. And in some cases, people paid upwards of $1,700 to get credentials, which would have allowed them additional access to different events and live performances and even some meet and greets. And now they're like, if you cancel that festival, I'd like my money back. Well, South by Southwest response was not to refund the money. South by Southwest basically said, you know what? We will give you credentials that you can use for one of the next 3 years up until 2023. And then we will also make it so that the next year you come to South by Southwest, the cost of your ticket will be 50% off. This is similar to what we saw with the airline industry. You have consumers who are like, that's not good enough. We're entitled to have our money. You have a lot of these consumers and ticket purchasers of a South by Southwest ticket and credential that have said, you know what, we were coming specifically to see a performer this year. We were traveling for some of these people out of state. We don't want credentials for another year. We don't want you to give us 50% off a ticket. We want what we paid and we want it now. South by Southwest is not interested in hearing that. Their defense is that they had in place a participation credential terms and condition clause that each ticket that they sold was subject to. And it basically says that under no circumstances will they refund your money. So again, you have people that are making the argument, South by Southwest, this year you canceled your festival, you're offering us the ability to come back another year within the next 3 years, but there's nothing to tell us that this is going to happen in the next 3 years. So we want our money. So this is another interesting one that I really would like to continue to watch. I have several friends that did buy tickets to go this year that were not refunded. 2 of those friends have lost their jobs, and the extra $1,500 to $1,700 they spent on the credentials could come in handy right now. So I want to know, Elisa, have you seen some of these similar cases being filed class action wise in Oklahoma? And what do you think will be the defenses in these types of cases where there's an event cancellation?
So, Kristen, we haven't really seen anything of this magnitude yet in Oklahoma, although there have been major lawsuits of this nature filed across the country. I will say, whenever you're talking about South by Southwest, something that immediately came to my mind was the defense of that these plaintiffs have lack of standing. That would be one of the first things that I would consider raising, because I would argue, if I was representing them, that this was an adequate substitution that they are offering for a bargain for exchange. And that could be a really valuable defense that they should consider raising. Absolutely.
Okay. I think that would be a very good offense. You know, there's just certain things that are out of business owners and service providers, out of their ability to follow through, they're out of their control. On a personal note, as I was preparing for today, I was thinking about the fact that, you know, me and you talked about this off camera a little bit earlier, that about 6-7 months ago, I moved into a new apartment. And one of the reasons I picked this certain building was because of the amenities provided. You know, they have a beautiful pool and cabanas and a state-of-the-art gym. You know, all these things that really made a difference between me buying a house this year and renting up an apartment, and then also deciding between this one and another one. However, since the second week of March, I have not had any access to any of the amenities. I can't go to the pool just to sit around. I can't go to the gym and pretend that I'm working out on my summer body. You know, those are things that are no longer on the table. However, I'm paying the same amount of rent that I did before. I'm paying the same amenity fees. There's been no modifications on my rent, no type of adjustment. And for me, you know, if I'm using the pool and they're having a company that's coming out every other day to clean the pool, and they're having to pay for that, and they no longer have to, but I'm still paying for it, there's a question is whether or not that's right. You know, when do you refund or adjust, and when do you not? I don't really see how these companies and service providers are going to get around the influx of cases. I think people are angered by that. You know, we're all affected at some level at different extents, but we're all affected by the issues involved with COVID-19. And I think that right now, more than ever, because of the economic hardships that so many people are facing, you know, even if you're getting back $100 a month on your rent because you don't have access to these services, that really could help a family, you know, in these times. What is your take on that?
So I absolutely agree with you from that respect. If I'm playing devil's advocate a little bit and trying to think of potential defenses here, I think that, you know, apartment complexes of this nature, they could potentially have an additional defense. You know, a few of the ones I already mentioned would apply, but just sheer, you know, unenforceability of certain portions of the contract, just changes in the law at the time. Across the country, we've had state, local, and federal mandates, stay-at-home orders that, you know, you can't socialize, you can't go out and use these amenities, and it's not necessarily, you know, the apartment complex's fault. That the law has changed, they can control that, and portions of the contract just can't be enforceable because of that.
In regard to the potential defendants in these types of cases, in particular when you're talking about apartments, thinking the defendants in those cases would they also be like the management companies as well as the property owners? Like, who would be the potential defendants named in those types of suits?
Absolutely. So the actual building owner itself, the management company for the building, you see typically even in any type of negligence or personal injury type cases, all of those defendants are brought into the lawsuit, and you won't see anything different here for sure.
And I guess these two, you know, we were talking again earlier about like gym memberships, you know, and golfing, you know, a lot of these fun things we were doing before that you paid a membership fee for that you're no longer able to do. And, you know, because in Texas, we've been in a rollout of reopening. So now I think we're at about 50% capacity for dining at restaurants and, you know, going to social events and things like that. So I'm wondering too, if there's going to be lawsuits in that regard. I think we talked a little bit earlier this week about, I think you'd read that some people were suing a gym for a membership, and we also discussed a case that you'd read about in regard to education and the fact that a lot of university, you know, paying tuition students are no longer getting the same type or level of education, and how they too want refunds.
Absolutely. There have been class action lawsuits filed against universities basically for reimbursement of room and board up until the point that the lockdowns occurred and they were forced to leave campus. You're seeing that right now at several different institutions across the country, and I anticipate we're going to continue to see those, as we've already heard from some universities that are not going to have students immediately come back onto campus, but are actually going to start just internet classes from their homes. So without an adjustment in tuition, there's definitely going to be some argument and issues that they see.
And that was my next question for you, is when you're reading about what's going to happen in the fall when people go back and they're saying we're probably going to do more online learning, has there been any indication that the tuition is going to be lower because of that?
I personally have not heard any institution come out at this point and specifically say, here are the areas that we are cutting the tuition rates. That is something I think that several institutions are right now scrambling to kind of figure out how they're going to handle it. Obviously, time is of the essence in that regard. I do know that some institutions, have already posted their rates and they are the same at this point. It's a hard line to draw, because while you might not have students on the campus, in some regard, the campus still needs to be maintained, if that makes sense. And a portion of the tuition, goes to those services. So it's going to be very interesting. Like I said, I think we are going to continue to see quite a bit of class action litigation occurring whenever it comes to universities in that regard.
Yeah, just based on what we've talked about so far, I think that our legal system is going to be backlogged for years to come with COVID-19 related cases. I just do. I don't see if there's any way around it. Again, personal experience, there's just days I'm like, who can I sue? Because, there's a lot of stuff I'm not able to do anymore. And, I want my money. So, Alisa, as attorneys, it is very common for us to see cases that come across our desk, especially as defense attorneys, and we just look at them and we roll our eyes. And the next one that I'd like to discuss is one of those cases. About a month and a half or so, I'd heard like a little soundbite from a radio or television program where they discussed that there was a person who was trying to get a class action suit filed against China. And I remember at the time, I just kind of brushed it off and laughed about it. But here we are. There are several class action cases that have been initiated against China. Here in Texas, there's Benitez White versus the People's Republic of China, which was filed in the Southern District of Texas Federal Court back on May 3rd of 2020. And in this case, it involves claims for wrongful death, gross negligence, unjust enrichment, and conversion. And the allegations are around the fact that they contend that COVID-19 virus originated from a Wuhan, China lab. So, again, I'm questioning, can you sue China? Well, countries are protected from being sued in the United States courts by the Foreign Sovereign Immunity Act, which is also known as FSIA. However, there are some exceptions to that act. For instance, the state of Missouri has sued China, and they sued them under an exception to the FSIA Act, which relates to commercial activity. You also have efforts that are being made right now in Congress that will make it easier for state legislatures to sue China and other foreign countries. But even if we get past the jurisdictional concerns, there's another concern as to whether these plaintiffs will be able to survive any substantive challenges that China perhaps will make against their claims. And then there's always the question of whether or not China or the Chinese government owed anybody in the United States a duty of, they had a duty to protect us or to warn us. As you and I were talking about earlier, we've had unprecedented amounts of unemployment claims being filed. You have business interruption. Our economy is not where it was just 4 months ago. So there's a lot of anger, and a lot of that anger has been channeled into these lawsuits. But there really are some substantive concerns about whether or not these lawsuits will be successful, including the fact of whether or not you can even obtain class certification. Now, and then once you file these claims, like how many litigants will you have? Is a claim, any potential class action against China could potentially have millions of people. So I'm just really wondering how these cases will indeed proceed. And then China does not have to respond at all. And if they do, they are required to do so within 60 days. As I noted previously, this particular case in Texas was filed back on May 3rd. The clock is ticking, so I'm really interested in to see if there will be any response from China. So just doing your research, what opinion do you have about not just the integrity, but the ability to successfully bring these class action suits against China?
I think it's going to be very difficult. As you said, China is not required under our laws to respond at all. I like that you brought this up because it shows, this class action was filed in Texas. During our first webinar, it was Business Interruption Part 1, I actually discussed the very first lawsuit that had been filed against China in the United States, and that was by the state of Missouri. And they filed a lawsuit against the Communist Party of China. And it was for fraud and deception, among some other claims for the COVID-19 virus. And so you are seeing these now pop up in different courts across the country. It appears both kind of, on different levels, class action versus just a state specifically. So it's very interesting to kind of see how this is going to play out. Obviously, everything involving around COVID-19 litigation is unprecedented, and we're going to have to see how it plays out. But I do think it's going to be very difficult to pursue this litigation, and especially to collect any potential judgment if there is one.
I completely agree with that assessment. Like, I just, just reading about these cases, I'm just like, wow, there's a big burden that has to be proven. And then can you do that? Like, you're trying to say that this virus was created in a lab in China. Like, how do you go about proving that? And then again, with just the amount of people that could potentially be a part of those classes, like, I just, this is one, as a lawyer, you just want to kind of sit back, eat your popcorn and see what happens. But it will be definitely interesting to see how this does work out, and what Congress is, or in our legislature, what their role in allowing these cases to proceed and kind of demanding some sort of response from China. Like, I'm interested in seeing what and if that will even happen.
This is definitely a historical moment in American, legal system. Absolutely. So it will be interesting to see how our government plays out.
Absolutely. And Alisa, another type of class action suit that we are seeing being filed in Texas, and I'm also aware they're being filed across the country, are in relation to cases involving detainees, specifically related to the Immigration and Customs Enforcement Agency, which is also known as ICE. Here in Texas, back on May 15th, a case was filed in regard to 10 detainees in the Prairie Land Detention Center that is in Alvarado, Texas. And what they've alleged in their lawsuit is that back, several months ago, ICE allegedly transported several detainees, upwards of 80, from Pennsylvania and New York detention centers, which have been known to be hotspots for COVID. They took those detainees and brought them to Prairie Lands Detention Center. And then very rapidly, as you can expect based on some of the research we're seeing, the number of COVID cases at the Prairie Land Detention Center went from 0 to 45. I was also, in researching this, saw that there have been at least 2 reported deaths at detention centers related to COVID-19. And in this specific petition, the allegation is being made that ICE did not take any precautions related to COVID-19 when they were transporting these detainees. Typically, the detainees, when they're being transported, they are all kept in very close quarters. There's no social distancing that's, being practiced at all. So there really does create maybe a breeding ground or more exposure for COVID. You also have lawsuits that are being brought by individuals, and now there's talk of class actions for them, where you have people that are saying, you know what, I have an underlying disease or pre-existing condition that makes me more prone to being susceptible to COVID-19. And you've got families that are involved. They're saying, my dad is in prison. He's supposed to get out at the end of the year. He has, high blood pressure, diabetes. He's 63 years old. Can you let him out sooner? Because he's probably safer out here than he is inside. And, you and I, we can do however much social distancing as we want. We can wear a mask, we can stay home, we can do all those things, but these detainees and prisoners do not have that same ability. So I really think you're going to have an influx, not just for those detainees and the prisoners on their own, but even the family members bringing claims against these detention centers and the prisons because there's an infringement upon a constitutional right to perhaps keep themselves safe. I mean, I think there's so many potential claims that I see when I read something about something like this, and I'm just wondering, what is your take on this and how successful these types of claims could be?
Well, we've already seen across the country, I've seen it in Oklahoma, governors and local just county jails are already trying to minimize the threat by releasing certain inmates that are for nonviolent crimes early. I know the Public Defender's Office in Tulsa specifically has been working even during the shutdown and when the courts were closed, working with the district attorney's office and judges to try to get some of these court proceedings for these minor offenses expedited so that they can release them from the jails as soon as possible. The key a lot of people have seen is trying to minimize the actual physical count of the inmates themselves. We've seen with some of the more heavily publicized cases lately, certain inmates who have gone in for arraignments and they are wearing protective gear, such as the protective masks, that sort of thing. You see a lot of jails that are trying to implement things of that as much as they can, social distancing, but it's very difficult. And you are seeing both family members and inmates filing lawsuits and petitioning the court, saying that they are unsafe for the reasons that you discussed. And it is pretty much at this point a state-by-state basis on how the governors and the local government are going to interpret and what they're going to do in place of that. But you have been seeing kind of a public outcry and concern of this nature, absolutely.
Yes, I agree with that. And, in discussing this presentation with a friend, they asked if we were seeing any trends about how courts are ruling when you've got these type of claims or just requests for hearings. And, this is really tricky because this is so fresh. It's so new that it really is not an identifiable trend. And I think that these are going to be cases that are ruled on case by case, maybe depending on what that specific claimant, what their history is, what their underlying or pre-existing conditions are. So we shall definitely see. And I know that you and I had discussed this earlier, is that, as attorneys, we do a lot of research and spend a lot of time figuring out which venues, jurisdictions are, the best for our clients and how they will rule on certain issues. And I think right now, because COVID-19 is so new and it affects all of us on some level, that we are not going to be able to really gauge or to predict what a certain jurisdiction will do. And I think, again, this is something that, 5 years from now, we'll still be trying to figure out.
Absolutely. And personally, seeing how this is playing out, I think it's going to lead to changes ultimately in how we handle more nonviolent offenses. And then in terms of bail, I think there's going to be some sort of bail reform in that these smaller nonviolent offenses, while in jail, we might see either a significant lowering bond or just more personal recognizance bonds issued by the courts to counter as a result of COVID.
And you know what, Alisa, that sounds like a whole another show that we could probably do just on that topic alone, especially what's going on in the world today. That's very on point. Just to kind of conclude what I'm talking about today, as you stated when we started this presentation, there is no industry that's immune. Like, we've all just kind of felt at some point during this whole thing that we are in a movie. Like, you could not have written the script. And as we kind of navigate what the next steps are, it is going to be very difficult, and you just have to kind of take what you do know and use that. And that's why, being at Holden Litigation, we're working with good attorneys that are able to do that. We can work with companies, service providers who have the threat of a lawsuit against them or who have actually been sued, and kind of help them to outline the plan of action proceeding and going forward. And then there's also probably some steps in education we could provide to companies that have not been sued right now, but just to advise them on maybe some policies that they could reform in regard to things like the refunds. I mean, I feel like this is something that we're going to have to take it kind of day by day. There's no script for this. Nobody could have predicted this was going to happen. And as we are definitely as a country moving forward and things are reopening, I think that all that means in this regard for what we're talking about today is that you're just going to have an increase, an influx in more and more COVID-related class action suits related to event cancellations or the lack of refunds.
Yes, and I was actually speaking to a client. It was a major national client last week. I won't name them, but some advice I gave them was you have recognition nationally, you need to be prepared whenever it comes to these lawsuits. Like I said, there have been a startling amount filed against all these companies. Amazon, it is a massive lawsuit right now, and it was for the early days of COVID in terms of price gouging of hand sanitizer and certain protective gear like masks and gloves, Lysol, that sort of thing. And those were just in the very, very early days of this. And Amazon actually did put a stop to it quickly. But that obviously wasn't enough. They didn't do it quickly enough. The fact that it happened at all exposed this liability, and they have a massive class action lawsuit in their hands because of it. And I think that all major corporations need to be prepared. We're seeing not only for things such as price gouging. I mean, you see, like I said, COVID-19 litigation in this regard is so vast. It's not only for things of that nature, but we're seeing it for the deception aspects, for just so many different areas. It's important to be prepared, know your plan of action. You need to be maintaining your business now regularly, because if there is a second wave, we're going to enter all the same issues again, and it's going to be probably worse. So that's the recommendation I would have at this point.
Absolutely. And one thing that we haven't really touched upon is, aside from the potential litigation involved, there's also the public relations aspect. There's going to be a backlash. You know, we were talking earlier about Cinemark. Cinemark is a company that I had one of those automatic withdrawal setups where every month they take out a certain amount and I get a free ticket and a free coupon for popcorn or whatever. And they have been the only provider of services that I've worked with who immediately, within like a week of everything kind of hitting the fan, that sent me an email and they're like, hey, we have suspended your account. We are not going to withdraw any more fees. You know, when the time is right, we will send you an email. And if you would like to continue to be a part of this program, we'll go ahead and continue to take out those fees. And I just remember the feeling I got. It felt good to not have to worry about one more thing, about one more membership to cancel. And the fact that Cinemark had their clients, their consumers' interest at heart. And there was no need for me to call them up or anything. And that's something I'll remember. And when things get better, when I go to a movie, I'm going to go to Cinemark. And I question about the airline industry in particular, when you have this public backlash, when you have these billion-dollar companies who are not refunding people with their tickets, when things are back to what will be our new normal and people are, not as afraid to travel, there's going to be airlines that they're not going to do business with because how they were treated throughout this.
Absolutely. And I think that, we're seeing all the major airlines having issues. I think specifically Delta is having a major issue right now with customer relations and the class action lawsuit against them. Their clients and customers are alleging unfair and deceitful practices on their behalf regarding ticket sales and refunds. That's obviously terrible PR. And that's something that they need to address quickly. And I'm sure hindsight, they wish that they could have had a better strategy implemented from the beginning.
And that leads me back to the question of, does the level of PR, the public backlash, do you think, like on a psychological level, perhaps this is actually increasing these companies' exposure to potential lawsuits because people are now mad?
I do think that it plays a part, not entirely, but it does play a part. And you actually, I have seen this with certain clients who from the beginning, they had a strategy in place, implemented and informed with their legal team on how to handle this COVID-19 situation, how to handle it from a consumer aspect, how to handle it internally. And the majority of those are faring far better than some corporations that kind of just went with it in the moment and were more reactive as opposed to proactive in their defense.
Ladies, if I may butt in, time constraints have come to fruition. Thank you both for giving us some good information about the lay of the land, what it looks like out there with regard to COVID. I do have a couple of questions that have come in. I would encourage the viewers to go ahead and type your question in if you have it now, because if we have time, we can go ahead and get to it. But if not, we'll still have it and we can address it after the presentation is over. The first question we have is from Florida, and obviously a state that's going to be hard hit. It's already hard hit. And I think this probably was touched on by Kristen earlier. Kristen, the questioner writes, which industry do you think has been hit hardest by COVID-19 class action lawsuits specifically?
You know, it's really too early to say, but from what we're seeing when we're reviewing these cases, it really does seem like the airline industry has been affected the most. Like, as you mentioned, I discussed earlier today that you have all the major airlines that currently have class action suits against them for the refunds. And then, I'm wondering, as people continue to travel, what happens if a person, goes and takes a trip, to Hawaii or whatever, and then they come back and they have COVID and they're like, hey, American, I thought you had some good cleaning processes in place. So, I mean, I just feel like it opens up the industry for even more lawsuits. But right now they have definitely been hit the hardest, and it will be very interesting to watch how they rebound. One thing that I will note is after September 11th, the airline industry was in a similar position, very hard hit, and they did rebound. So I think that there is some faith that things will eventually get better. But right now, I think they certainly have been hit the worst, and I don't think it's over. I think it will only get worse for them.
Yeah, that's unfortunate, but I also agree with you as well. I do note that the cruise industry has taken a big kick in the teeth. All of the major cruise lines are being sued right now for various things, but they're definitely in that mix as well as the airlines. We did have a question come in as well. I have another one. I'll leave it up to both of you to determine which one wants to take this one. Is there anything you're hearing relative to first-party class action claims versus carriers for denials based on lack of direct physical contact or a lack of virus exclusion in their policy? Have you heard, what kind of defenses have you heard? And you did touch on a few of them, but have you specifically heard of any exclusory language being utilized or exclusions in a policy for an attack on a carrier?
So if I understand the question correctly, a lot of carriers do have virus exclusions written to their contracts. We first saw this occurring after the bird flu, is what they called it, several years ago.
Yep,
and
I remember.
As I've discussed previously on other webinars, that is when the insurance industry, it appears, really thought that bird flu was going to be what COVID-19 is. They thought it was going to be a massive pandemic that caused, complete chaos and disruption. So that's when we first started seeing these virus exclusions really written into a lot of these policies. And absolutely, we have seen carriers citing the virus exclusion. We have seen already massive amounts of lawsuits being filed challenging that. We have seen certain legislatures in certain states trying to pass legislation, or at least suggesting, in an attempt to pass legislation to proactively exclude, to remove those virus exclusions, which is very interesting and something we need to watch. You're seeing these more in places, I believe, like Rhode Island, New Jersey, I believe, they've had legislative members suggesting things of this nature. In terms of the aspect I believe you said of lack of physical contact or physical injury, that is specifically, it sounds like, referring more to business interruption coverage in that, and that's what I'm thinking, is if they mean there's no, typically with business interruption, there has to be physical damage to the property, or if they mean actual person itself, that could be a negligence aspect that they're arguing an emotional distress claim would not be covered under certain employers' insurance. That has been a major issue that we've been seeing as well. That just simple exposure alone without actually contracting the virus, that you would potentially have these type of negligence lawsuit. In terms of the physical, like property damage, that has been an argument for exclusion again by many insurers that they have done regarding business interruption coverage. We've also seen lawsuits by business owners of that nature.
Understood. And I remember you talking about those in the previous webcast with regard to this, the lack of physical damage to a building or a body. Is it a damage to the lungs? Can it be verified? Can it be quantified? Can it be traced? Kristen, eBay, is eBay going to be responsible for these sellers price gouging, or are they just too far removed from it? They're just a platform like a bulletin board. What's your take on that in the last few minutes?
I'm going to throw that back to Elisa, because I know that she had done some research on how this has impacted eBay and Amazon.
Absolutely. Actually, I've just recently really gotten into the eBay case. So I can tell you right now that a lot of people have questioned some of these corporations, these class actions, where it's kind of almost a third-party transaction, where they have independent sellers on these platforms that are selling, and, well, how can eBay be responsible? Whenever it was, some guy in Minnesota who sold them these items at a marked up rate. And so the theory behind these class action lawsuits against eBay, Amazon, parties of this nature is basically that, this is their platform. They allowed these sellers to sell these items at these outrageous rates. For example, eBay had people selling, N95 masks at, I think it was sometimes like 500% markup, things of that nature.
Yep,
but they were allowing this to occur. And not only were they allowing it, they were complicit in the act because they were taking their cut of the profits whenever it was sold. So from that aspect, that is how the majority of these major corporations are being brought in. That is the theory of the plaintiffs.
Understood. In times like these, it brings out the good in people, and a lot of times it brings out the worst in people. I was recently looking online with regard to class action lawsuits being filed, and the old preacher Jim Baker's been sued in a class action lawsuit trying to hawk a snake oil, a snake oil cure for COVID. And he's being sued, I believe, in Missouri. Here's another one, and y'all can determine which one of y'all wants to take it. Clarifying do insurers have a class action exposure if they allegedly fail to conduct a complete investigation?
Yes, they absolutely do. We're already seeing that occur. And I'm assuming investigation means that there was potentially a COVID-19 outbreak within their facility or significant exposure, and they did not properly warn or investigate, cases occurring or potential for cases occurring. We are seeing lawsuits against employers for negligence and things of that nature. Absolutely.
Yeah. In fact, I saw that, of course, OSHA guidelines have requirements of reporting. And if somebody's not following them, then that's going to be a problem. Now, can OSHA be a basis in and of itself for a lawsuit? And in workers' comp, not so much. Maybe in district court litigation, maybe. It doesn't become anything more than just persuasive evidence in some
Sure.
workers' compensation states. But
and something that I have said in regards to OSHA is whenever employers or corporations they're re-entering and they are concerned about potential negligence claims regarding any potential outbreak in their facility. We saw this with Smith Farm quite a bit, which was the meat packing plant that had
Smithfield.
sorry. So they had the outrageous outbreaks within their facility of so many employees contracting this. When it comes to OSHA, one of the best ways to build a defense against negligence is to follow OSHA and CDC guidelines. And I've discussed that on previous webinars. If you are complicit in following those guidelines, that is building a strong defense against negligence claims by employees.
That's wise counsel. Wise counsel. Y'all better do it out there. At this point, we're going to have to wrap it up. I want to thank everybody for visiting with us today. Kristen, thank you. Elisa, thank you for taking time out of y'all's day to come see us. And I would like to also remind everyone to join us next week as we have part 2 of business interruption presentation due to COVID issues. We've done one already. We're doing another one next week. So we appreciate if you folks to join us, and wish you the best and admonish you to stay healthy out there. Thank you.
Thank you.